Hey everybody, Todd Vandermide back for another edition of Freedom Steel. We've got some breaking news today with the Supreme Court. More after the intro. Hey everybody, Todd Vandermide, former NRA contract lobbyist, Illinois gun law guru, and sometimes called the Gun Santa on a few online platforms. But hey, we have some breaking news today in the Supreme Court, so cue the alert. So after getting the last cases issued out from the Supreme Court today with birthright citizenship and some ruling on transgender athletes and whatever, the court a couple hours later released an orders list. And in that orders list, they granted cert or certiorari to two semi-auto ban cases. One of them was the challenge in Cook County called Viramontes. Another one was out of the state of Connecticut. So this is important. So now we know that the Supreme Court is going to be taking up square on whether or not semi-automatic firearms can be banned by calling them assault rifles. So when the court accepted this, the question that they put down is, quote, whether the Second and 14th Amendments guarantee the right to possess AR-15 platform and similar semi-automatic rifles. So one of the things that I've had a contention with is everybody gets hung up on the AR-15. The AR-15 is just a euphemism anymore for semi-auto rifles. Just like Xerox became a synonym for copying, the way the question is presented, is not just ARs, it's about all semi-automatic rifles. And we should actually expand this, or be a bit more specific, that when we get into the details and the briefs and everything, that this should be, magazine-fed semi-autos, whether it's fixed or otherwise, and that, the detachable part becomes really important. But parts of this get really intriguing because if you go back, Viramontes is a per curiam opinion that's only 3 pages long. It's not very long at all, and if you take out the headers and everything, I think it boils down to 2 pages. But one of the things that I think one of the reasons Clarence Thomas and the court voted to accept this case is a quote here from Viramontes. Quote, we held in Bevis that it is the plaintiff's burden to demonstrate that the text of the Second Amendment, viewed through the lens of historical tradition, protects the regulated conduct. Technically correct, but it's the way that they applied this test in Viramontes that kind of runs afoul of things. They go back and cite Bevis, which was the preliminary injunction of all the consolidated cases, both in the Northern District and the Southern District. And he said that we held plaintiffs had failed to show at the preliminary injunction stage that the covered firearms materially differed from machine guns and military-grade weaponry, which the Supreme Court instructed can be banned under the Second Amendment. But now we've got Walford, and Walford jumps in here, and Walford asks some different questions when it comes to, how this test is applied. In Walford, the Justice Alito wrote when it talks about the 3 questions that fit into Bruin's first step, quote, first, does the law apply to the people, which is to say to all members of the political community. Second, does it concern any form of arms, i.e., any weapon customarily used for offensive or defensive purposes? Third, does the law place any restrictions on either keeping, i.e., possession, or bearing, i.e., the carrying of arms? So here it is. We now have this big clarification from Walford that Viramontes got absolutely wrong, because as the language of Walford says, it says any form of arms. And I think you're going to have the left just go absolutely bananas once this starts playing out, because well, you mean hand grenades? You mean, look, let's not get through the absurd. There's a theory I've got about bang versus boom. I'll get into that in another video. But so Viramontes and this Connecticut case, and I'm not familiar with all the nuances of the Connecticut case, are the ones that are being up there. Cooper and Kirk is the law firm. I have worked with Pete Patterson and David Thompson on other litigation. Cooper and Kirk has represented me personally in my challenge against the Cook County ammo and gun tax. So I am familiar with these two lawyers. They're both top-notch lawyers. I think this is going to be a good throwdown for them. I don't know if they're each going to take one of the two cases, they're going to split the time, or if they're going to flip a coin and see who gets to go to the show and be on. But congratulations to David Thompson and Pete Patterson on either one. Other couple questions. Is Kwame Raoul going to file his own brief from the state of Illinois, or is he going to pile in with 18 other attorney generals and whatever? Cook County State's Attorney's already released a statement saying that they are going to vigorously oppose this. Yay. We want you to throw everything you've got into it and come up with the most BS reasoning in the world so we can go through it and we can get the biggest win that we can get. There's a lot of different machinations of things that are going to go on here. I did some looking up of other cases this term. So in this term, if a case was argued in October, then the last of the October cases was decided on 3/31. In the November sitting, there were some cases that were decided very late into May of the sitting. So depending on, it would be better for us to get in October orals, but a lot of people are just figuring a year from now we're going to be sitting here getting one of the last rulings of the year when it comes to this. So one thing about this is that since it is FPC and SAF that are the big players in this, there are a lot of other groups out there that are available to do amici briefs. And I think that one of the things our side needs to work on very adeptly is to take all the issues that are here and cut them into a pie. And organizations need to set egos aside and they need to pick a slice of the pie. Hey, you over here deal with magazines. You over here deal with, common use. Over here deal with, how we apply the test at the first step and how they got it wrong. I think that some of the Illinois groups should be working on some amici that clearly tear apart Friedman and tear apart the Beavis decision and the other BS that has been coming out of the Seventh Circuit. I think we can even clip in how wrongly decided Schoenthal was and how that it didn't apply the Bruin test properly at all and started making up new tests out of whole cloth. So what does this do for us with the other Illinois cases, the Southern District cases, Barnett and Company, FFL Illinois, and Harrell and all that stuff? Well, there's two schools of thought. One, this panel of the Seventh Circuit may just sit on it. But there's an alternative school of thought that Judge Easterbrook, who sits on the panel that is handling the Barnett consolidation, that his ego won't let him sit there, that he will win, lose, or draw, try to push something through so that he gets to tell the Supreme Court exactly what he thinks. If he's on the losing end of this, I don't know that that'll happen, but it would be nice to get a ruling out of the Barnett guys. But it looks like they don't have to. You still got Cheeseman out in the 3rd district that we're waiting on a ruling. I hope they come down, and they come down with a split. One of the things that's real interesting about Viramontes and the issue in general, there's no circuit split on this. And I think a couple of the anti-gun lawyers have pointed out that without a circuit split, which is usually one of the big reasons the court takes issues up, without a circuit split, for them to reach down and decide they're going to take this issue, that's sending a signal. And they don't like the signal that they are reading. So I'm part of this. It's my personal opinion that I think they have reached down and done this at this point in time because Viramontes was relisted 21 times. I mean, I think that's a record on the number of times for a relist to then be taken up. It surpasses Dobbs. But with it, I think that with Virginia passing what they did, Delaware doing what they did, other states coming online, Minnesota trying to do it, I think the justices have finally come to the point where they realize they've got to nip this before it gets out of hand. Otherwise, it's going to look like half the country's for this, and the Supreme Court just overturned the will of half the country. Yeah, no. So I think Justice Kavanaugh's prediction came true. There are bets being wagered on whether or not he will be the author to vindicate his dissent in Heller 2, which was his part of the, he was on the losing side of the semi-auto ban that was challenged in the District of Columbia. There are, and his comment in that was pretty interesting because as he wrote towards the opening of his dissent, in my judgment, both D.C.'s ban on semi-automatic rifles and its gun registration requirement are unconstitutional under Heller. That's Heller. Before Bruin, before any Walford or anything else, he didn't even think registration could start. So the question for us is going to be, how much can we squeeze out of this? I'll go in and dive into the Connecticut law. I'll do some more boning up on what the Cook County ordinance is. But I think it's been a great 2 weeks for us in the 2A community. And I'm not going to join with all the naysayers about that, the court's going to stick it to us because birthright citizenship didn't go our way. No. I'm going to enjoy myself tonight, and I think we all should. It's been a long time coming. I think we're going to win. I think we're going to win big. I think that it's going to be on us to put down a lot of amici that point out just how we need to close up the loopholes and give the Supreme Court a roadmap to make sure they don't leave any wiggle room for Gavin Newsom, the New Jersey AG, Virginia. And this now, maybe, with this pending, could it give a couple of judges in Virginia the ability to hold out their injunctions until this is decided a year from now? That would be an interesting take to where they pass it and it never actually gets enacted. But hey, we'll have more on this. I've been having some computer problems. I've been struggling most of the afternoon with things here to get the software up and running, and it just might be time for a new computer. But anyways, thanks as always. Please copy, share, pass this around on social media and whatever. We really appreciate all of it. I'll be having more content coming out in the next day or so. And as always, frag out.